Wherever you are placed, I am visible. Today, this is in fact, a continuing session of constitutional law. But still, I have allowed all of you who are not a part of the earlier sessions. Either you may continue with the further lectures, or you may have treat it as a demo class. This is up to your discretion. We have already discussed the introductory part of Canadian constitutional law, sources and nature, amendment, federalism, a substantial part of judicial review also. But because some of you have joined just now, I'll just give you a brief overview of what we have already done in a 5 or 10 minutes. And before even discussing the Canadian constitutional law and the subject and syllabus of NCA, I wish to discuss with you, and earlier also in the demo class I have discussed this part. When you have, most of you are the law graduates, and when you have entered into the law course, there is some knowledge and information you have already gathered during your +2 studies, up to +2 studies, or maybe after graduation, be it a polity, be it a history, be it a geography of Indian law. Now, when you entered into the law course, and the first lecture of the teacher is Constitutional Law of India. He says preamble. He says there was a British Raj, and in 1947 India got the independence. This is nothing new for you, because you have already read this, that there was a British Raj, there was a medieval history, there was ancient history, and during the British Raj how the law developed, then the drafting committee was constituted after independence, how and when the Constitution of India came into force, what are the basic steps. Please mute, please I request all of you, please keep mute your mics so that there should not be a disturbance, right? Now, this information or this knowledge you have already gathered, and nothing was new when the constitutional teacher started with the constitutional law of India. Now, we, being a foreign trained lawyers, have been allowed by the Canadian legal system to get a certificate of qualification equivalent to the JD or a LLB of Canadian legal system. But they have certain requirements. You are well aware that there is a establishment of NCA, the evaluation is there. Now there is a 5 core subjects. It is just, I don't know why and how this hype has been created. It is just like 5 subjects of your semester. Nothing more than that. If you have done LLB in India and you have appeared in all the subjects, each semester may be constituted of 5 or 6 subjects, and you have appeared after 6 months in every semester exam, and you have qualified with colors. What is the difficulty in qualifying these 5 subjects? Nothing. There are only 2 issues. One, you don't know the legal history of that country. You don't know the history. You don't know the geography. You don't know the political system. And started with the NCA syllabus. Here you have been stuck. One. Second, the material, maybe the books from where you have to read and study. These are the 2 only issues what I have found from all the discussions with the NCA candidates. Now the first, when you have to decide that yes, I have to undergo an assessment, or I have been assessed and I have decided to appear in the NCA exams, start with the history, polity, geography, legal history of that country, and then start with the particular subjects. Now you know what is the geography of that country, how they constitutional law has developed in that country, how the legal system has developed in that country, how the political system has developed in that country, then you have an overview. You have the information and knowledge of that particular foreign nation. Then if you start with the syllabus, you have a little bit of idea how the things are moving. Suppose you are, the first part is Constitution Act 1867, which was known as British North American Act 1867. Now, if you have not studied the political or legal history, you are stuck there. What is this? And then when we read its first part of preamble or first part of the statute, it is that there are Dominion of Canada comprising of 4 provinces. Now those provinces, they say Upper Canada and Lower Canada. If you are aware and having the information and knowledge of the geography of that country, the political system at that point of time, then you can easily understand, yes, Upper Canada is this province, Lower Canada is this province, and because the Britishers dominated this particular part, French dominated this particular part, that's why it was called Upper Canada, Lower Canada, and then they have joined together those 4 provinces and given the authority or consent to the British Parliament to frame a law for them. That is called the first stage of constitutional history of Canada. So 1867 British North American Act was passed by the Westminster Parliament. So meaning thereby there was some transfer of power with the Canadian Parliament when they have developed the federalism in the Canadian legal system. Federalism means not in ideal terms, but practically we can say a dominion, a central authority and the regional authorities, and they are constituting a federal structure and run the administration and the other organs of the state. Now 3 organs, you are well aware: legislative, executive and judiciary. So under the federal structure, these 3 organs were established under the British North American Act 1867. But Supreme Court of Canada was not established. Like in India, Supreme Court, High Courts and even the district courts are the creation of the Constitution. They say there was a judicial system, but there is no provision for the creation of the Supreme Court of Canada. So if you are aware about, you have the knowledge, you have the information about that country, then you can easily understand the law subjects of that country. So this is the first requirement. Gather the, please mute yourself, please. Now, if you have this information, you can easily understand. Then you will find that these are only the 5 subjects which we have already appeared in the Indian law system. So you have to read like this, you have to study like this, and there is one difference. There is one difference, but here in India also there is a great change in the legal education now. We also believe in applicability of law. How construe the facts, understand the law, apply that law on that fact, and reach to a conclusion. Here they are raising a very hype about IRAC. We are adopting that. We are understanding the same system. It is only when we are using the word IRAC, it is a very big word. No, nothing. Why you worry about it? It is the same thing. Frame an issue from the facts, give the reasoning by applying the law, and reach to a conclusion. This is IRAC. Nothing. And you are applying it. When you are appearing in the law subjects in India, there is a proposition, there is a problem, there are questions which are problematic in nature. You apply the law in the same way. So my first and the last submission to all of you is, don't worry about it, don't bother about it. It is just like 5 other subjects of law which you have already appeared in Indian law with a different context. If you have the legal agility and ability to understand the law, it is not a difficult task. No tutor is required, no notes are required. Now, one thing more. If you, this is again the difficulty. We apply for NCA, get the assessment, find out the syllabi, and then started getting the notes. If you have only to qualify NCA, no problem. Go to the notes, cram it, and then appear in the exam, you may qualify it. But if you want to enter into the Canadian legal system as a lawyer or as an educator, or you are entering into any other arena on the strength of this your law degree, then you must study in detail, in depth. This is called extensive study. And then yes, in view of the exam, you may have the intensive study. This will help you to understand that law, subjects of law in that country. Ultimately, you have to deal with that law throughout your life. It is not a temporary issue. Second, you will able to get the bar exams qualify very easily. Very easily if you have this extensive knowledge of all these 5 subjects. So if it is a temporary or ad hoc arrangement of qualifying NCA, all right, go to this part and do this intensive cramming study. But if you want to become a part of that legal system, want to establish yourself as a lawyer or as any person on the strength of that lawyer degree, then please read it extensively and then understand that law, apply that law on different subjects, how the courts have interpreted there by applying the law on a particular set of facts. Enhance your knowledge, hone your skills, so that it will help you throughout your life. It is not a temporary arrangement. So with this, I am only giving you the overview. 1867 BNA Act. Then 1875, there was certain consensus, and that consensus led to the control of authority over the UK Parliament. The consensus, that agreement was that whenever there is a request from the Canadian Parliament, only then the BNA Act can be amended. Very interestingly, the BNA Act has no provision of amendment. There was no provision of Charter of Rights or fundamental rights in the BNA Act. So whenever there is a question of amending the BNA Act, then a consensus or an agreement was arrived at, and on the basis and on the strength of that, the UK Parliament may make the amendment to the BNA Act. It's very simple as either of the province or the UK Parliament pass the resolutions, make the request to the UK government laid their statute, proposed amendment before the Westminster or UK Parliament in accordance with law passed that law, then it would have been, it was an amendment to the BNA Act. So thereafter, Supreme Court of Canada, because the Privy Council was the authority, final judicatory authority, then Supreme Court of Canada was established by an ordinary legislation. Then subsequently in 1930s, the Privy Council's authority was taken over and the Supreme Court of Canada was declared as one of the final adjudicator of law in Canada. Then this whole story moves on where there are various stages, and finally in the year 1982, again a request was made by the Canadian Parliament to the UK Parliament to pass the Canada Act 1982. Now this Canada Act 1982 is comprising 4 sections only. This request was made to the UK government laid before the UK Parliament passed this law, and this Canada Act 1982 contains the schedule in the shape of a Constitution Act 1982. So Constitution Act 1982 is not an independent statute but a schedule attached with the Canada Act 1982, which came into force, and finally the complete transformation of power to the Canadian legal system was there, and finally the UK Parliament lost its complete authority over the Canadian legal system, and the federal structure is again continued to be adopted. The 2 major lapses in the BNA Act 1867 have been now fulfilled by way of insertion of amendment clause in the 1982 Act, and the Charter of Rights have also been made the part of the Constitution Act 1982. So these two things have happened in the constitutional history of Canada. Now, again, Supreme Court of Canada has not been given the constitutional status under the Constitution. Now, this is another important thing, that like in India, there is a one constitution. Here in Canada, there is not one constitution. Constitution is there, but it is comprising of different statutes. Now, BNA Act is now known as Constitution Act 1867, Constitution Act 1982, and other imperial statutes, etc., which have been prescribed under Section 52, subsection 2 of the Constitution Act 1982. So those all form a complete Constitution of Canada. And Section 52 says that Constitution of Canada is a supreme law of the land, and any law contravene the constitutional provisions or the Constitution shall be ultra vires. So the Constitution has been given the supreme status in Canadian legal system. So with this, sources, nature I have just given you federalism, sources I have given you a little bit of idea. Then the amendment, section 38 to 45, these sections contemplates 5 types of amendments, and then the concept of federalism, and then the principle of judicial review. Now, there is a distribution of power in a federal structure. Section 91 and 92 describe that the provincial and the federal parliament, provincial legislature and the federal parliament have a different matters to legislate. So under Section 91, the federal parliament has given the competence and jurisdiction to legislate on all the matters which have been listed under Section 91, whereas under Section 92, the provincial legislatures have been given the competence and jurisdiction to legislate on all the matters which have been listed under Section 92. Like in India, there is a union list, state list and concurrent list. However, in Canada, there are only 2 lists in the shape of Section 91 and 92, and the residuary power rests with the federal parliament. And if there is a contravention or a contradistinction or a contrary aspect between the federal law and the provincial law, it is always the federal law which shall prevail. So, who will determine when there is a conflict? Suppose a federal law has been made by the federal parliament, and someone says that it is within the legislative competence of a provincial legislature, or a provincial legislature has made a law and there is an issue that it is within the matters listed under Section 91, where the federal parliament has the competence to legislate, or both the matters overlap each other, whatever be the circumstances. So meaning thereby, when there is a dispute, who shall resolve it? Here comes the judicial review, that is the third organ which shall determine the validity of a law and the competence of a particular legislature to legislate on that issue. So this is called judicial review. When a judicial body, when a judicial authority is determining the validity or intra vires or ultra vires of a legislation, we can say